Okay, I'm going to, ask that, Jubilee, you and, Esme, since this was part of your part of the budget, and I think you have some understanding of the, at least, as much as I do, of the zoning issue, that,
Not.
as much, you know, as much as I do about it, but if you can look at the standards and, pull out 3 or 4 components, to actually put in a definition in this bill, that,
Look at the emergency shelter standards, okay.
yeah. And, so, and then get that to Katie, or send it to me first so I can see that if I
Okay.
want to change them, that'd be great. Then we don't have to spend a lot more time on that right now. Okay, department for, oh, cool, morning. Department for Children and Families. Yes, everybody okay with that? Understand what that means?
Yeah.
Where are we? I do, on definitions, the bottom of the page, bottom page 3.
That was so much.
Okay, so I don't want to complicate things, but I feel like I need to bring it up, and I went back and forth with Katie on this, between using department and agency. So giving responsibility to the Agency of Human Services or to the Department for Children and Families. All of the budget right now sits within the Department for Children and Families. And they would still be the entity that oversees, the, designation of, a community resource, regional resource organization. But I'm just bringing it up because, in my head, I did go back and forth between AHS and, DCF. Is there anybody have any strong thoughts about that, or am I just overcomplicating something? Thinking about it.
Not a strong thought, but just we heard a lot of testimony about different departments within AHS that play a role or should play a stronger role in this, such as DMH, ADH, and Dale. So just kind of wanted to make sure that that's kind of incorporated and included and addressed, that AHS as a whole plays a large role. It's not just DCF that.
Yeah, I just thought of something in the, committee, the advisory committee, I'm gonna say that AHS secretary or designee too.
So I'm just wondering, in terms of, being too prescriptive, well, I mean, I'd wonder if the agency itself would have a preference in terms of its ability to comply with all these things.
Mhm.
If it's statutorily DCF versus statutorily the agency. So that might be good to get their specific info.
Monica's here.
Are you looking at your input right away or can you follow up?
Yeah, no, you can follow up, yeah. And if the secretary or commissioner has, like, there might be there might be a section that it might be more relevant to say agency, and another section that might be more relevant to say DCF. I think, like, I'm thinking about the planning section, about inserting the secretary, just for that very reason that people talked about other departments. I think it probably makes sense for the agency secretary actually to be, the person calling that first meeting and recognizing that, okay, all these players have to play well in this system, and it's not only on DCF, to help address these issues. So, that'd be great, Monica. Thank you. Okay, so I think we should add a definition for Agency of Human Services. Has to be. Okay, definition for extreme weather event. Or I guess maybe I should ask, would it be helpful to go through and to see how these are used in the context of bill before we kind of think about the definition of them.
Well, I mean, I think that there's some discussion to be had maybe about whether, the broad, the shelter, or whatever it's called, that basic level should be limited to extreme weather or not. So if it were not, then the definition wouldn't be needed at all.
Okay. All right.
If it is, I think the definition as it stands may be a little.
It's helpful to finish going through all the definitions,
Okay.
because we only have a few more.
Yeah.
And then once we get into the bill, we might come back and say, we need this or don't need this, or make revisions to
Sure.
the.
Okay.
And even though I know it's such as, which means that's just examples. I think lightning storms and tornadoes should come off the list because that's like
Not
not very predictable and not, it's like,
that prevalent.
Yeah.
well, we're getting
It
a
would be
lightning
hard,
storm this
yeah.
afternoon. Does that mean
You gotta hurry up and get somebody in.
that would, or tornado in particular?
Every time a lightning storm is, yeah, and then
Does that
what would be,
trigger
is it
an opening or
5% or 10%? Yeah, that's hard.
Yeah.
But it's also scary that,
Right.
you want there to be options for people to take refuge from a lightning storm.
Right, but refuge
Yes.
is different from an emergency shelter. It gets, I think
Tricky.
it doesn't need to be in the such as list because it can be included as any kind of extreme weather event or weather events.
I think honestly, by listing so many, it feels like it's trying to be all inclusive.
Yeah, right,
Yeah.
that's the problem, yeah.
Yeah. So we deleted lightning storms and tornadoes. But I just wrote down refuge because I think that's honestly, that's what the concept of the emergency weather event shelter is. It is to seek refuge from weather events, but, so just kind of keep that concept in the back of your head a little bit.
Well, although yeah, because it's specific, I mean, the whole statute is specific to overnight refuge, basically, as opposed to.
Well, it could be overnight, it could be might not be overnight.
Right,
Yeah.
no, right.
Yeah. Okay, homeless. Household. So we spent a lot of
We spent a lot of
time
time
on this last year.
We really delved deeply into
I
that.
feel like we did a
There are
great job.
There are a lot of new people who might be entitled to weigh in, but just so you're warned.
That's painful.
Yeah.
We spent hours talking about
Yeah.
definition of household. So.
Are there any
Are
questions?
there any
Question. I hear you.
Yeah, go ahead, Rita.
But to get housing, you don't have to be a Vermont resident. You just have to sign a paper saying you'll stay in Vermont. So that kind of takes away from this. Because somebody could,
If you live in Vermont in the moment.
Oh,
And
in
you're
the
a
moment.
resident.
Yeah, you live. It doesn't say you must be a legal resident. It just says you live in Vermont.
So,
hard though, because
It might be living in the
they
woods.
watched that morning.
excuse me, it's
That's
Smith.
fine.
Katie, I may ask, rather than me saying this 5 times, there was a Supreme Court ruling, I don't even remember how many years ago, but it's like 25, 30 years ago now,
Mhm.
that defined what residency is. This language reflects that. But it might be, I don't know if it's something that is relatively easy to find.
I think I might have a one-pager about durational residency
Oh, okay.
requirements. I think that's what you're thinking of.
Justified last.
I did. I must have put something together when I did it. So let me take a look.
Because this question came up last year as
It
well.
comes up often.
Oh, okay, yeah. Anyways, okay. So there's Supreme Court rulings that go back decades now, that I believe this definition is consistent with. Okay. Regional resource organization, that is a new definition, because it's a new concept. And this is, again, designated by the department or designated by AHS. Not sure. In this situation, it probably will be by the department, but I don't know.
I think in the context of a definition, it works. And again, I think that we'll have a bigger discussion about should we name who we really mean versus
Mhm.
a new name for a specific purpose.
Yeah.
And my other question there was that, we later, when we get in the meat of bill, we say that it has to be a community action agency. So the designation, like, if we're saying it's gonna be a community action agency, then why is there a need for the department or the agency to designate them? Because we're already saying that it's gonna be this organization.
That's
I think
that's
maybe
basically the same.
the other sticking points were, it was like, it has to be one of them, but they also have to be turning in reports on time. There was like other,
Criteria to be
Criteria.
designated. So,
it is kind of confusing.
Yeah. It needs to have a little tag. It's like when a professional has, and you can also do this because you have a certification in this.
Yeah.
So, the thought behind, and shoot holes in the thought, right? That's fine. The thought behind this is that it's given a specific name because it is a different role than what even though community action is named, when it comes to the criteria, it's given a different role. So this is an expanded role for an existing provider group. And so I somehow felt a need to be able to cite that as it being something different.
Here
Yeah.
we go. So how about a regional resource organization means a supplemental designation for a community action agency that is certified by the department to lead the agency.
Good.
If it has to be a cap, as stated later, then why not say it's a designation for a cap that has this that has
Let
been
me think about that.
approved for this supplemental role. And organizations designated to do something is its own whole separate problem when it's in statutory language, because then that term gets converted into a new name for you're a designated agency.
Well, that's why I don't, yeah.
But
Purpose didn't call it a designated agency.
yeah. Designated agency's been, I think, misused to rename community organizations that should not have, that makes it confusing. Who knows what a designated agency means?
Well, everybody in this building.
Yes, but not the public. I mean, the public thinks, but there's something else.
Yeah, I understand. I
Yeah.
understand. So, okay, so let's think about how that evolves. And in the process of talking about who these organizations are, I will be upfront and say that the secretary, the Agency of Human Services, wants to be able to make a decision, to decide, not to automatically assume.
Right,
That
you
you
are
meet this
approved
once.
for this purpose.
Yes.
And I am, yeah.
Yeah.
Isn't that like
Agree
a
with that.
designation or a certificate, whatever it's called, like what the PCCs have to do or the DAs have to do, where like every few years they have to kind of make sure that they are complying and they're providing the services that they said? Isn't that the piece where the agency has a role in saying, yes, you qualify, you are going to be doing the things that.
Let me just ask a question. Monica, do the community action agencies, or anybody in the room who might know the answer to this, do the community action agencies have formal AHS rules like there are designation rules for the community mental health and developmental service agencies.
I will follow.
Yeah, I don't believe
I
that they
don't
do.
think They do. either.
So if they did, then that would
That
be
would
the
be-
case, but they don't.
It sounds like you're defining more of a preferred provider. It would be the preferred provider, because we got our designated agencies and then the preferred providers.
Right.
In this scope of practice that you can actually establish that whole
Well,
scope of preferred providers to the CAPS.
And so is there, now this is something the CAPS might push back against, but should there be, because, some of their money comes federal funding direct to them, but should there be a process by which, so absent this, but integrated with this, should there be a process by which you have gone through a process to designate you as a community action agency? In other words, you have the required elements. I don't know. I mean, I'm just putting it out there because I don't think it exists right now. And so we are a little bit trying to fit a square peg into a round hole. Does that work? I don't know. So I kind of like your concept, Dan, about your, a regional is designated specifically for providing this, or arranging to provide, because it doesn't mean that they provide it all themselves, but they have to have arrangements with other community providers.
And I'm sure we can come up with a consistent alternative word than designation.
Okay.
Because it really,
Yeah,
I'm just pulling up the other statute.
yeah.
And it was interesting that you used the term community mental community and, you didn't say designated agencies.
I did that for you on purpose.
Oh, I see. Okay. Because in fact, the statute says it exactly that, it does not abolish community mental health agencies. It just says community mental health agencies are designated for this
Yeah.
purpose.
It's
And
become
then
a
we
shorthand.
turned it,
Yeah,
it's more than a shorthand though. That's the problem.
well,
Yes.
yeah. Well, we could have a long discussion.
No,
about
I
this,
know,
but-
and I didn't mean to
Yeah.
get into that. I'm just saying that
But the relevance to this is that we are in the community mental health and developmental disability designation process, we are saying in state statute that you are the people who are going to provide or arrange for the provision of these
Yes.
services. And so the relevance here is we are saying the same thing about community action agencies in the context of leading the region's response to preventing and addressing homelessness.
right,
And that should
I just
it
think
should
it-
just say
yeah.
homelessness, not unsheltered.
right. Yeah.
Uh,
It just leads to the risk that the same misuse of that term
Yeah.
gets adopted
Yeah.
more broadly. And I think it's a significant misuse that's developed over the last couple of decades that is misleading to the public as well. And using the identical language lays it open to worsening the. Anyway,
Yeah, I remember we had this same discussion when we were talking about the parent-child centers. Because they wanted to use the term designated and we figured out some way to say it without saying designated.
all right, let's look at that.
Just
language
say
then. Authorized to have been
Authorized.
approved for
Appointed,
the.
assigned, recognized, selected.
The cap that is approved for the delivery of.
Yes.
I like authorized personally.
Okay,
Madam Chair,
yeah, go ahead.
I have an answer from the CAPS.
Yeah, okay, great.
So, Amy Schallenberger for the record. They comply with national standards. The CSBG organizational standards are a comprehensive set of standards. And they are designated in statute. So we can send you the citations if you want.
So that sounds very similar to the parent-child centers who follow national standards.
But not.
I'm not sure these standards are voluntary in the same way the ACC standards are, but I will confirm.
The that they are or are not
I'm
voluntary.
not sure they are. I think they may have to follow these in order to be.
Two. Okay, so yeah, if you send them to me? Will you send them to Katie at the same time? Okay. So it might actually be helpful to see how community action agencies are referenced in state statute. So that we're not doing something that interrupts that or changes that without knowing it. Or we might need to amend that potentially. Okay. I see the looks on people's faces. This is a slog. I'm just
Yeah,
telling you, this
yeah.
is the part
This is
of,
the-
this is the part of, lawmaking that is a slog, especially when we're talking about a bill that has dramatic ramifications for Vermonters. So, like, honestly, every word does matter. And, I remember one time we talked about for a very long time.
It was the registry,
Oh,
no,
Yes.
yeah.
APS registry.
And we even
Yeah.
had our
Yeah.
Supreme Court judge come in and talk
Yes.
about it,
Yeah.
like we.
Yeah.
It was abuse or the abuse.
Community Action Agency only comes up twice in statute. The first time it comes up is under Regional Microbusiness Development Programs Operation.
Okay.
The OEO shall provide grants to each community action agency for the microbusiness development program at each community action agency. In the event that a community action agency is unable, as determined by OEO, or unwilling to perform the required service, OEO may provide grants to another qualified regional entity. That's one.
Community services people.
Oh, Community Services Agency.
That's how it's fixed.
Community Services Agency. Okay, thank you. Services Agency. Well, if it's defined, then we should be cross-referencing that or using the same term. Okay.
When you find that, Katie, we can see it up on the screen.
They're authorized, not designated childcare, parent child.
Okay, here we go.
For people new to this activity, this also is something that we have to do our best, and we're not always perfect at, but making sure that we are not putting something in new law that is contrary to something that's in existing law. So this is part of that process.
Want me to go through this?
Yeah, let's just look at this briefly. Yeah, can you make it a little bit bigger? Is that possible? There we go.
Finding and purpose, recognizing the economic well-being and social equity of every Vermonter has long been a fundamental concern of the state. It remains evident that poverty continues to be the lot of a substantial number of Vermont's population. It is the policy of the state to help develop the full potential of each of its citizens so that it can contribute to the fullest extent possible to the life of our communities and the state as a whole.
So I just want to, you get some sense now of how the structure of this bill fits into things like that have already been passed. So that's a findings and purpose. That's similar to our findings and intent.
Is the purpose of this chapter to strengthen, supplement, and coordinate efforts that further this policy through the strengthening of community capabilities for planning, coordinating, and managing federal, state, and other sources of assistance related to the problem of poverty, the better organization, utilization of a range of services related to the needs of the poor, the broadening of the resource base of programs to secure a more active role in assisting the poor from business, labor, and other groups from the private sector.
Then it goes on, it looks like, to talk about OEO and the,
Yep. The director, well, do you want me to skip OEO?
yeah, well, I mean, I think that,
Designation.
again, we have to think about how the bill that we are doing here relates to other aspects of state statute and whether those sections are repealed or modified somehow.
So here you have a designation.
Okay.
The director shall designate private nonprofit community-based organizations who have demonstrated or who can demonstrate the ability to provide services and activities as defined in the previous section as community service agencies. So we skipped over that 3902B. Here's the list of activities. Components of those services and activities may involve without limitation of other activities and supporting facilities designed to assist low-income participants. Secure and retain meaningful employment, obtain adequate education, to make better use of available income, to provide and maintain adequate housing and suitable living environment, to obtain services for the prevention of narcotics addiction, alcoholism, and the rehabilitation of narcotic addicts and alcoholics.
Old language.
A lot of old language. Obtain emergency assistance through loans and grants to meet immediate and urgent individual and family needs, including the needs of health services, nutritious food, housing, and unemployment-related assistance, to remove obstacles and solve personal and family problems which block achievement of self-sufficiency, to achieve greater participation in affairs of the community, to make more frequent effective use of programs related to the purpose of the chapter, and to coordinate and establish linkages between government and social service programs to assure effective delivery of services to low-income persons, and encourage the use of entities in the private sector of the community in its efforts to ameliorate poverty in the community.
So I'm thinking that all of those things, and particularly when it's talking about housing and connections to services, I'm not thinking that we necessarily need to adjust any of that. I am thinking because we are essentially eliminating the HOP program, and I think that this should be the commissioner. In other departments, it's the commissioner. So I'm not sure it should be the director of OEO. That is whatever it's calling it, designating them. So I'm thinking that maybe we should be amending this as part of this bill.
It's that addicts and alcoholics section while we're at it.
Since we can.
Yeah.
That's where, yeah,
Change four to low income.
Yeah.
yeah.
Okay, so OEO, you don't want OEO director doing the designation, you want the commissioner of DCF.
Yeah.
Yeah. And update language. Okay, there are two more sections, I think. So each designated community services agency is to determine the need for activities and services in the area served by the agency and shall thereafter prepare a community services plan which describes the method by which the agency will provide those services. The plan shall include a schedule for the anticipated provision of a new or additional service and shall specify the resources which are needed by and available to the agency to implement the plan. The community service plan shall be updated annually. I'll go on to 3905, but I think you might want to cross-reference here the new language you're creating.
Yeah. Just
Saying that there is this additional, whatever it is, recognition, authorization, pursuant to this new chapter. Okay, 3905. Each community service agency shall administer its program as set out in the community services plan and as approved by its board of directors. Each board of a nonprofit community-based organization that is designated as a community services agency of this chapter shall have an executive committee of not more than 7 members, who shall be representative of the composition of the board, and the board shall be.
We don't need to go through that part.
Okay.
Yeah. And what chapter is this again?
This is in Title 3.
Oh, Title 3, Chapter 59.
59.
59. That's interesting.
Yeah, it is.
My question is, since we're amending this anyway, do we want to say that it has, like, that needs to be statewide coverage somewhere? Because we want to make sure that our program is statewide and consistent. So, if the commissioner is designating these community, what are they called? Service agencies, the CAPS, shouldn't we make sure that there is white coverage?
I'm just looking to see if it says that
I
there's
don't
someplace.
think, yeah, I
Yeah.
skimmed through it and I didn't see it.
it might say something in the rules. But that's probably an element that is, should be required, it should be in state statute. Yeah.
So
So,
collectively statewide
Yeah.
coverage, okay.
So, yeah, I was just in the regional planning and needs assessment stuff. So now that I'm aware of this, then we would revise that section to be relevant to the community services plan that they already have to do.
Okay.
And, Matt and Amy, I'm not, do they actually do that annually?
I believe they do. They were talking about it a bit last night when we were discussing the draft.
I'm just thinking that in other community service areas, it, annually is a lot to do a thorough process, and I'm just, in here, we were proposing, I think, every 3 years.
I don't think they would be upset about it for either time.
Yeah. It's consistent. I don't know if there's any federal reason why. So Monica, can you find that out? If there's any,
I think we just sent you some.
Did you?
information about that.
okay. What did it say, since I don't have it open?
I think I think we use report,
Okay,
there's also some reviews that will. 4 years, but that was.
okay, all right. So then we would, the community service plan requirement, we would be changing to 3 years.
so glad we found this.
Well, I had notes here. I said, there's gotta be something in
Something,
statute
yeah.
for, it, but I did the same thing you did, and I wouldn't have known to look at,
Action,
right? I wouldn't have known to look up community services organizations.
So are you looking to get rid of the regional planning needs assessment section and put it as a criteria under the approval process? They're consistent with those.
I'm not sure that I would say we're getting rid of it. I would say that the whatever it's called here shall include. Because this is specific to homelessness and housing. So I'm
Whereas
not,
this is more
it's more
broad,
generic and
yeah.
broad, yeah. And I think we are also saying that this plan be submitted to the legislature, yes. It doesn't say there. So, and maybe we should be amending that, because we're referring back to that plan.
Okay, I'll amend it in both.
I'm not sure, yeah, I'm not sure where, okay. So, what, I think what we'd be looking for is not 5 plans to be submitted to the legislature,
Mhm.
but for the department to sort of
Aggregate.
roll up and aggregate the data from the 5 plans and present that to the legislature.
And this is a nit, but like the plans should all be in the same format. Because we don't want the department to get 5 different plans that are completely different and then spend hours and hours trying to.
So maybe something, a form created by the department in accordance with the parameters or form.
Yeah, like a
format.
template or like something that they're all using the same things.
Thank you.
Makes it easier to analyze results. So for better or worse, it's drawing upon historical knowledge of the community mental health and developmental services agencies and the parent-child centers and the things, you know, trying to.
Which I just sent the language to everyone. Because
Yeah.
I was looking that up while you were
So we're
looking
getting
at
at
that.
this,
So
yeah. So, I mean, it's not like we don't have
parallels. and
parallels
examples.
in other areas. I see this as, you know, very parallel to both of those. Yeah.
Mhm.
Okay. All right. So we just jumped around a little bit.
So yeah, and I
Sorry.
feel like we should come back to 7.
Okay.
The definition of ROO, because we kind of were talking about what the department or the agency's role is in this authorization or the designation, for lack of a better word right now. And I don't know if we've landed on that answer yet.
You know, I mean,
Yeah, I'm not sure yet. Not yet.
Okay.
Okay,
So
because
let's-
yeah. So, I mean, I think we're honing in on a definition,
yeah.
but I think it will be easier to understand when we
Once
see
we
the
go through,
language.
yeah, I just want to make sure that was still outstanding.
It is.
To be
not- not
determined,
done, To
yeah.
be determined, yeah. Okay, so, the Vermont Homeless Emergency Assistance and Responsive Transition to Housing Program, otherwise known as Vermont HARP.
Say heart.
I know, I like Vermont HARP better, to be honest
That's
with
what
you.
I didn't even, I saw it immediately.
Yeah, I
When
know you
showed
did.
you, I stopped it to you. I was like, oh,
Yeah,
really?
With an H on the end, come on. right at the bottom.
Silent H.
Silent H, there we go, silent H. Okay, so, and actually maybe, so that we start to create that sense. I don't know what you do in statute, but can you,
You want a short title?
yeah,
And you want it to be heart and
Yeah.
not hard? Okay, so remove to housing.
no, well, no, that's in the long title, but not in the,
I know that's.
it's a silent H.
or you could say the Heart Housing Program.
That's what you said.
All right, just do heart, and we'll call it heart. But yeah, so we don't have to spell it out, and so people start to refer to it as that.
Okay, in statute, I mean, I can do a short title and say like, we will refer to it this way. Have you ever seen like a short title where the first section says, this program shall be referred to by this title? But I will probably still spell it out or refer it to the program in statute, but that would sort of colloquially be what is referred to after. Does that make sense? You're good with
Give
that?
it a try.
Okay. Heart. Got it.
Because otherwise, like, this happens a lot, and speaking as someone who's had to work within like state and federal.
Yeah.
Is when we use the same terms as like home.
Yeah.
You were operating under the like Federal Bank of Boston home loan program and also had home, like using the same
Major
terms.
confusion.
It is so confusing, especially for case managers who are working on the ground. So I would, yes, let's use a different sounding.
We should use Home Hearth. Is that it's your heart?
Or just, or V-Hearth or something, but it's gotta be, it's gotta be, I like V-Heart. But we really have to like be, and all of our work in
I
this
get that.
building is like using at least slightly different from federal.
And I'm not tied to this. This is, I just
Yeah.
like, I ran across this in my research and I'm like, oh, I kind of like that. But so if somebody has a different name, I'm fine with a different name. Like what Jubilee said, yeah.
Heart too, in my head, I was thinking that, be heart.
Okay.
V-Heart or V-Heart, but yeah, just not calling
We
it.
Snip, we got V.
I got the yes. I know, it's something different, yes.
But it's so.
Maybe so.
VT
Okay.
Heart, Vermont Heart. VT Heart, no. Then we're getting
Why-
away
why
from
syllables?
one letter.
Why don't we go with V Hearth so that it is being consistent with what we actually call, what the program is called, V Hearth, okay?
There we go.
All right. So it's a grant program operated by a statewide organization. Okay, this is the beginning part. Okay, so let's have a conversation. The way this is set up is, well, let's just even talk about the concept. So the concept is that during those extreme weather events, that municipalities would have an opportunity to, in advance, obviously, apply for funding from VLCT, which is the statewide organization representing municipalities, but not otherwise named. They would have an opportunity. So some of the money that, we're talking about here would be allocated to VLCT, and then they, municipalities with a concentration, which I don't think it says that in here, but I intended it to, with the areas most impacted by homelessness being given priority.
Yeah, I would like to see, I mean, the department in contract should be identifying geographic access.
And in their grant agreement, they would
Right.
indicate a prioritization. Yeah,
Right.
yeah.
But priority both for highest percent and geographic,
Mm-hmm.
and we don't want three in Colchester and none in.
I'm sure Doug
wherever.
wants 3 in Colton.
That was specific, yes, he was making comments yesterday.
I know.
Colchester's desires, so.
Or maybe Colchester doesn't want any. That
Well,
might be the more, that might be
that's-
more. Oh, the package.
Oh, I know this.
Okay. So Katie, all right, well, let's talk first about the concept. So I've been really thinking about the concept of integration, and then this really because I was trying to have municipalities deal with an organization that they already have an established relationship with. I thought about, them being the ones to, administer this, grant program for municipalities. It makes it less integrated with the rest of the temporary and interim shelter services. So at least in my mind, it kind of seems to sort of set it a little bit outside of that. And we do have communities now who have done this, like the city of Burlington has done it. Barry has done it. I don't know about others. Those are the 2 I'm familiar with. So thoughts about that, in terms of the integration, where is this, do people like this component or do they, I was trying to, let me tell you what I was trying to do. So I was trying to address way back when we were talking about budget adjustments, and Anne brought up the issue of somebody, we shouldn't have any eligibility for people who are truly at
Unsheltered.
who are unsheltered and have no place to be. They should have access to a place to be safe during,
I didn't say during.
no, I did.
Okay, just to be clear.
No, you did not.
Yeah.
But I couldn't figure out how to operationalize the other. And so this was an intent to try to get at that concept that, yes, there's not really any eligibility for this, but it is very time limited, and expected to be of short duration. But, and, within the capacity of the municipality, like if they set up a 40-bed shelter and you have 60 people coming, you might not be able to serve everybody, but, so that was the concept, and I'm interested in folks' thoughts about whether or not you like this component, or you don't like this component, or you think it should be structured something different, or you think we should ditch it all together. Yeah, go ahead,
I have
whoever.
a structural question.
Yeah.
In my mind, when thinking about this, and Eric, you brought this up yesterday, the establishment of this VHearth program would include elements such as, cold weather, extreme weather shelters, the ROs, funding from, and the way it's structured here, they're kind of separate.
Well, they're 1, 2, 3 under the program.
But then 2203 is the extreme weather event shelter.
Then they start
2204 is the, and to me.
This just provides, sorry,
No, that's
no,
okay.
keep going.
Well, so and this might be my just not understanding this, establishing this 2202 has 1, 2, and 3, but then we go to 2203, which is separate from establishing.
You want to explain
Can you
the
explain
the
that? I'm
organization
sorry.
of it, Katie?
Okay, so the 2202 is just laying out the 3 components. And then the next 3 sections dive into each of the components in more depth and talk about who is administering and what types of services are offered within that.
Okay.
That doesn't have to be the structure. We could get rid of those 3 separate sections and we could pull it all into 2202. I could create like a subsection B, C, and D, and I could have each of the elements fleshed out there.
Okay,
I mean, I was thinking about that saying.
Yeah.
okay. I see how it's supposed,
Is that confusing to anybody else? I mean, if it's confusing, we can restructure it in a different way, but go ahead, Zon.
No, I just am agreeing that I find it a little confusing.
So maybe if it's, I mean, what I was just mentioning to Teresa, part of it is the fact that it's talking about different, types of shelters and as we've been discussing the program as a whole, which is what this is breaking out, what are the key components, includes the whole, case management component for all different levels, including people at risk of homelessness
Yeah.
and prevention and all. So it might help in seeing it as the different pieces of, to have a number 4 that somehow reference case management that includes, preventive, what's the word we have in there somewhere for high risk, for likelihood of something housed, fragilely housed. Precariously, thank you.
So actually, I would like that to be number 1.
one.
Okay, yeah, 1, 2, 3, right.
That's what,
yeah.
yeah, because so for me, like the number 1 doesn't really
It's not
lay
it's
out
not
the
the first thing,
program.
right.
Yeah.
So that might help, yeah, if it's number
This is really
1.
helpful, because when thinking about this, because we've spent so much time thinking about shelter
Mhm.
and shelters, this is a much more inclusive program. And so we do need to have something that talks about prevention at risk and retainage of housing.
And if you flip that, then the paragraph, the subsections would start with case management. Because the way it is now, it is there's extreme weather, emergency, temporary, transitional, and then case management. Those are the subdivisions before you get to eligibility. So if it's 1, 2, 3, 4 in the order you were suggesting, then the case management section would appear first in the order following.
But yet isn't a component of the other 3, because it's not in the extreme weather.
Well, I think that is something that we have to talk about.
Yeah.
So that was on purpose.
That was going to be my next comment when we actually started talking about number 1.
Yes. So, okay, so before we jump to that, I just want to make sure that, to summarize, in 2202, in the establishment of the program, we'll have a new number 1 that references prevention, at risk, precariously housed, and retainage of existing, I guess that could be under prevention, but it seems to be a big issue, given the data that we've seen, and the state auditor's office. Did I say that yesterday? Did I forward that to people?
Yeah,
Okay.
you did.
All right. And what I'm wondering out loud is whether we talk about the components we don't really talk about the components of that. We just say, this is the broad category.
Right, because the components come
Come next.
into the section, right?
Yes,
You don't
okay.
need to go.
So that's
into it.
number 1, and then the other 3 would follow that right now. Okay? We might revisit that, but
Yeah.
that's what for right now.
And then it sounds like you're doing away with the separate sections, 2203, 4, 5, and 6, and moving those into 2202 as subsections. Did I catch that correctly?
I like them
don't
being their
think-
own sections.
Yeah,
to be
I-
honest.
You do like them as their
I think it's
Okay.
fine if number 1 goes, that the new number 1 will help kind of lay out what this program does, and then we can have the separate.
Okay.
I think that will alleviate some of the confusion.
I
So
think
also-
part of it was that it seemed like 2202 was like, why do you need 2202 if we're then going into 2203, 4, and 5?
right.
Yeah, but yeah.
So the other thing that predicted, number 2 and 3, as they are now, start by saying temporary emergency shelters, transition shelters, and that's also what the headings are. But number 1, the current number 1, starts by saying it's a grant program. And maybe it should match with whatever an extreme weather event shelter program, through a grant program. It just somehow putting those words up first.
Yeah, I see what you're saying. Yeah.
So that it aligns with
Can
the,
you try me again on that one?
okay, so forget about the new number one order. So the current, okay, there's number 1, 2, 3, and then there's the sections that align with each.
Mhm.
The sections, the label 2203 says extreme weather event shelters. 04 is emergency temporary shelter. 05 is transitional shelter.
Mhm.
But if you look at 1, 2, and 3, 2 starts off with temporary emergency shelters, or actually it should align,
should be.
emergency
Yeah.
temporary shelters.
Yeah.
And then 3 is transitional. So number 1 should be extreme weather event shelter as the opening words to then saying, that is created through a grant, I don't know the wording, created by a grant program. I'm just saying
You wanna
those
put that
words
at the top.
start, so that then you have that better
I understand
alignment.
what you're saying.
Yeah.
You get that, Katie?
I got it.
Okay.
It's another thing for new members, like, we've all been working together for a while, so it's kind of amazing that Katie and
Katie's
some of
done,
the.
how long have you done human services, Katie?
Years.
Yeah.
It's like they share brains.
Yeah.
Yeah, she can read some of our
Yeah.
minds.
And I
Not always, though.
And I do, so I am realizing, I just want to say this out loud, that there's I want people on, people who haven't been in the committee before, to make sure to speak up about things or questions that you have. I realize those of us who've been in the committee and been through this process before last year are doing a lot of the talking. I realize that. And I just want to make sure that speak up if you have something to say, or a question to ask, or you think something doesn't make sense, or any of the above, okay? All right. Because silence does indicate agreement.
Yeah.
Just saying.
Well,
Wow.
it also indicates active listening.
Exactly. Yeah, no, yeah, that's very good. Zon, go ahead.
Well, so listening to all this right now, and I've been thinking for a while, I mean, it's not the moment to do it, but I could see way back under the intent section, framing it up in something like this. It strikes me that the intent is to remove or eradicate or dispense with as much as possible homelessness. That's the intent. Right now, we say the intent is to have a transitional moment. Again, I don't want to talk about it, but I can see ways to maybe frame that section up similar to the way we're talking about this right here that might bring, at least for me, a little bit more understanding to the whole thing. I see there are a number of tools that this committee's proposing to use in its intent to reduce homelessness, eradicate homelessness. And I could see framing it up differently. Anyway, just saying that now. So as a
Thank you.
placeholder.
Well, I mean, we do say the very first intent is that homelessness be addressed in Vermont. I mean, that's the very first thing.
Yeah.
Are you saying just,
might be enough. Just stop there. And then the next sentence might become one of the tools that we're using. This is one of the ways we're going to use it.
okay, I understand what you're saying.
Yeah. And then we're going to do some of these other things, aligning it with the and maybe frame out the broad scopes of the 3 types of housing or a shelter that we're currently talking about. And then everything falls, that becomes the program. Anyway, I'm just saying it now. I imagine we're going to talk about that again at another moment, but I just wanted to say that.
Yeah, no, I appreciate it, Zon. I mean, that honestly, that just makes the very first thing be very simple and direct. And then other things follow that. I like that idea.
Okay.
So in terms of the extreme weather category. So there are kind of 2 pieces in my mind that first of all, in terms of the question of who should run it, I think that needs to tie into the concept of it somewhat being a triage opportunity, that there needs to be the degree of linkage so that people coming in because they're unsheltered are, whether it's done by the municipal staff who are there, or by, the RROs, that people are identified as being eligible for a more enhanced shelter if they show up there. So that's the really critical gut linkage, I think, is that, because I see that this ties into, what I see this is specifically, this is for unsheltered homeless.
Yeah.
This is, this is that kind of last ditch get a shelter for people. But that will include some people who can't get into a higher level, even though they're eligible because it's at capacity. But this means they've got a roof over their head as well, rather than being turned away. For people who are unsheltered, who have no other option. This is that safety net, if you will. And that's part of the reason I think limiting it to extreme weather is too narrow, and that maybe it should be, it could be just for extreme weather, just like it could be potentially just overnight shelter. It depends on the needs in the area and the funding and so forth. But I wouldn't want to see it restricted by definition that this can only be for extreme weather events. Because if there's a municipality or an agency or whoever's running it that has the capacity to make it, year round, then I think we would want to encourage that if somebody is unsheltered, and again, there's always choice, doesn't want to be living out in the woods, that there is a roof to come to as part of trying to eliminate unsheltered homelessness.
I think that, and also, I mean, if you look at Vermont, where unsheltered home, there are some areas where there are higher concentrations of unsheltered homelessness. So for some areas, and kind of putting that in that regional planning, maybe it does make sense that they have one of these longer term. Another, maybe it's a smaller population of unsheltered, and they determine the best way is for, other methods. So I really like that flexibility. One of the things just around the service and like making services available, I'm just thinking of our OPC language. I'm going to have to look back. But we put some language about that kind of like offering of service connections in there. And so I'm wondering if we could use that as a starting point. Because I firmly believe services should always be the person's choice, but they should be offered at every possible avenue. And so this is an opportunity for folks who may be living largely disconnected and unsure and have trouble accessing those services. But the more they are offered them, the more likely they will eventually be able to access and participate in them.
That's one of the places where peer support can be good.
Exactly. And that's what I'm hoping, that peer support element, it will be something we still.
Okay.
But
yes,
also that it not be, I think it's better if it's not outreach people coming in, but rather it's the staff there who are, building relationships. But I wanted to,
I just need to interrupt for a second, because we have witnesses at 11, and we're kind of switching gears here. And we'll come back to this, obviously, because I will say that the intent of this was much different than what you two were talking about. And municipalities, I am 100% certain are not interested in sort of like running shelters 365 days a year.
well, and this is only if they want to, and they're applying for a grant for that, though. It's maybe.
Yeah, but we want them to do it in places where there actually is a need during extreme weather. So I don't want to inhibit their applying for it by putting requirements on this aspect that would inhibit them from actually applying for a grant. So anyways, we'll pick that discussion up more. We have 3 bill introductions that we're going to do right now. And partly this is to give us a little bit of a break, give our minds a little bit of a break, because we're going to be doing the rest of this for a long time. Thanks, Katie. And so bill introductions for people who have not been through this before, we have, obviously you can see we have a whole host of bills up on there, but there is no way that we will get to all of these bills. But there are certain bills that I have asked the sponsors, the lead sponsors of those bills, to come in and talk about why this bill is important. for us to review. This is really their opportunity to make a pitch to our committee to take up the bill. That's what this is. And the first one is the esteemed Representative Topper McFawn.
Where?
You have to, we're on camera, right? I just spilled coffee all over my.
Well, you still didn't spot where your tie covers it, so you're.
We wouldn't have noticed.
That's the way it goes.
Okay, so, welcome Representative McFawn.
Thank you. This is a great room. I really like it.
I know, right? Well, you're welcome back.
A lot of time in there.
Anytime, Topper.
The word we just used at the end was here,
Yeah, like in that spot.
so I'll, serve it for you.
Oh, that's only till it's.
Yeah.
It said lunch club, that's what.
Bill,
All right.
Okay,
I know everybody's listening.
we are right now.
Very attentive.
H92. Why is this here? I'm going to talk from my own personal experience with families that I've taken to the Human Services Board. I want to, most of the testimony is going to be about one family that I was attached to the hip to, but it was about 2.5, 3 years to get to a hearing with the Human Services Board. Now, in that journey, we would go to these phone meetings, and the family was treated, in my opinion, with disrespect. The Human Services Board is supposed to be a place that individuals or families could go if they have a complaint and have the ability to tell the Human Services Board all about what happened to them in a layperson's language. We went to these hearings and it was like being in a courtroom. The family would make a statement. The lawyer from the agency would say, objection, just like you're in a courtroom. And the hearing officer would say, I don't ever remember them saying, your objection is not well taken. It was always, your objection, I find your objection valid. Therefore, that family who was trying to get services for their son would not get the information that they wanted to get on the record. Now, I know that all of those hearings are recorded, but the Human Services Board doesn't get all that stuff. They get a report from the hearing officer.
Because it just happens right now that the hearing officer is the one that you're presenting your case to.
Yes.
And then they take that and.
Then eventually, if the Human Services Board feels that they should hear it, then you'll get to the Human Services Board.
What is, I'm new.
Yeah, I was just gonna say. Thank you. I was just gonna. Right, I was just gonna say why this is important. So,
Okay.
services in the Agency of Human Services, all Medicaid services, okay, and there are many Medicaid services in the Agency of Human Services, have to have a right of fair hearing, appeal if your services are being denied or terminated or reduced, and so. Or your not just your services, but your eligibility. So there's many steps before you get there. But the ultimate step is before the Human Services Board. So it is, it's a body, it's supposed to be an independent body that it's not made up of people who are involved with the departments for whom the decisions are being made, but it's supposed to be independent. And they decide whether or not the family or individual's complaint is valid, or whether the department is acting in accordance with its rules and regulations, essentially.
Who puts this board together?
Well, this is, so, one of the things that I learned in this process of, I'm a co-sponsor with Topper on this, is this, that the Human Services Board, at least in Katie's recollection, had not been discussed or addressed at least in the last 15 years. And it is a very important element of services provided by the Agency of Human Services. So Representative McFawn, based on his experience with trying to assist one family, but we have heard this honestly from multiple families, feeling like the individual and the family don't have really an opportunity to present their side of the story. And so there's very little in the statute. A lot of this is about their procedures of operation. So anyways, so that's sort of the reasons why. Representative McFawn, is there anything else that you'd like to say about this?
So I just want to make the committee aware of the fact that the common ordinary person gets very shook up when they're treated like they're in a courtroom.
Very intimidating
It's
situation.
intimidating and frankly, I really felt bad for this one, but I've been there more than once. But for this particular family, I felt as if it was worthy of us taking a look at what the Human Service Board is doing and making sure that they do what they're supposed to do in a way that's transparent and a way that allows people to get their complaint on the record, and somebody in between is not shutting them off all the time. Just imagine if you're trying to tell somebody about something and it's really personal to you. You're talking about your son with autism, and the son can't speak for themselves at all, and you get interrupted all the time while you're trying to lay out what the problem is, and they
Yeah,
get into that court.
we get the gist.
So we need to do something about that so that the Human Services Board does what they're supposed to do.
Thank you, Representative
Thank you.
McFawn. We appreciate it.
You're very welcome.
It's an honor to have you in our committee room.
It's an honor to be here.
I
Thanks
came up
very
here
much.
just for that.
Representative Bloomley, you're next.
Not just for that.
Yeah.
But I came a little early.
I knew that Topper was going to be speaking.
Yep, this is all on our committee's webpage.
8:30.
All members of the Human Services Committee, this is Tiff Bloomley, representative from Burlington. And thanks for the invitation. So in recent years, there's been some press and discussion within the education community about the use of seclusion and restraint. And 2 years ago, Chair Wood and I sponsored a bill to ban the practice of seclusion and restraint in schools. And many states have been doing this over the last couple of years, safeguarding children from these practices because they're broadly recognized as leading to mental health trauma, physical injury, or in some instances, particularly in the case of prone restraint, death. This year, knowing that House Education is up to its eyeballs in work related to school reform, I chose to focus on reducing the use of seclusion and restraint on children and youth who are in custody of the Department for Children and Families and who participate in residential programs.
So if I could just ask a question. So
Yes, you may.
2 years ago, the effort was begun with related to schools,
Mhm.
and that did not pass?
Oh, no, it got a hearing. Chair Wood testified in front of the Education Committee, but
It took some testimony. There are regulations that govern it. However, there really is insufficient oversight by the Agency of Education with regard to seclusion and restraint. And they honestly didn't know how much seclusion and restraint was happening. I mean, they did a survey, once this bill appeared and, so that's a whole other thing about the Agency of Education. Thank you, Representative Lee.
So Rule 4500 establishes guidelines and mandates a process for reporting incidences of seclusion and restraint in schools.
but it provides a little protection to children in DCF custody. According to the Office of Child, Youth, and Family Advocates Annual Report, which I know you all heard about and read, DCF districts aren't providing regular updates to local schools about the custody status of children. So the Agency of Education isn't aware if students are in DCF custody and unable to report that information to DCF. And though required to do so by DCF, residential programs are not all or regularly sending reports to DCF about these instances. And in effect, we have very little information about the use of restraint and seclusion in the 43 residential programs in which 83 Vermont youth live. So the bill lays the groundwork. I'd love to see a ban on this, not going there right yet, because we need better data. And so the bill lays the groundwork for better data, which I hope will significantly reduce the number of times these practices are used and train educators in other methods of de-escalating situations with young people. First, it develops a system for consistent data collection and reporting. Can I just say if I say the office, well, you know I'm talking about the OCYFA? Okay, just, okay. So the office that you gave birth to estimates that annually.
It's really me.
I just said you.
The committee, yeah.
They estimate that annually there are hundreds of unreported restraints and seclusions of children in DCF custody. I think 13% of the contacts that are made involve seclusion and restraint. They sense that that number is probably much higher. Baseline data will provide DCF opportunities to work with providers to lower their reliance and use of restraint and seclusion on Vermont children. Second, if we want to limit the practice of seclusion and restraint, we have to define what we mean by those words, because schools, inpatient psychiatric units, residential treatment programs in Vermont define them differently or fail to define them at all. So it's mushy, and providers may not know, what is seclusion, what is restraint under Vermont law. Third, the DC database overhaul, which again, your committee helped kickstart, and which has been put out to bid, should be designed to integrate this data related to instances of seclusion and restraint. And then finally, we need to build the capacity of all residential programs in the use of less harmful alternatives to seclusion and restraint. So professional development needs to be a part of the solution. It's a short form bill because I believe the aim is really straightforward, and because I trust this committee, Ledge Council and the Office of Child, Youth, and Family Advocate to flesh it out. You know these issues very well, and the systems that affect their lives. So thank you for inviting me in. And I'm happy to report, I'm not an expert in this. Both Chairwood and I got an email from somebody, probably 3 years ago, who is a teacher in a school in Vermont, who's very, very concerned about these practices and the rate at which they were affecting particularly children with disabilities, and children of color, disproportionately. So at any rate, I hope that you'll have time to take it up. And if not, I'll just be rooting for you next year.
Go ahead, Brenda.
I used to work at school for 10 years. In some cases, though, it's safety for the student. Keep them safe. So, because this is kind of broad, being there, sometimes it was safe for the student being restrained, or they would have hurt.
Yes,
I've seen it all.
And I know that you'll take, if you take this up, you'll take testimony from
Maybe
folks,
something
in
if it's for the safety of the child, that would be a worry.
That actually was in our, in, H four.
Is it there?
No, I'm just saying, in H 409, the bill that,
Yeah.
we had in, for education, last biennium, the safety of the child language was in there, yeah. So we would look at, so it's Ann then Todd.
So, I'll try to be quick, but I come out of the world of the Department of Mental Health. And their standards, which apply to residential programs that they're running, which we just, the legislature applied last year to children's psychiatric residential programs. And I, other than schools, but in terms of residential facilities, I was operating under this myth that unless, unless there's a law that permits it and defines it and so forth, that's like assault or kidnapping if you're held in a certain area. And so I wasn't even aware that that was permissible to have child in a locked facility or room and so forth. And we have really clear standards for psychiatric residential programs and what you can or can't do. And so it's almost inconceivable that we would not expect the same standards, which include training on alternatives, which include standards for exactly when you can, because the safety of others or the person is at risk, and has a lot of thought and work in developing it. The other piece, so I really endorse the need to do this and make sure that we're at a very minimum protecting children to the same degree. But the second piece is that we did act 20 years ago regarding transportation of children and adults. And after a while, it seemed like we were getting good reports and they were making good progress, and we stopped requiring the annual reports. This year, we asked for an update on where DCF was on that. And they have been struggling at this point for well over a month at collecting that data for us, which should be at their fingertips. But I also went back and looked at the last report that was issued. And I was kind of, because my focus was so much on mental health transports, I'll acknowledge this, it wasn't deeply into DCF. Looking at the DCF reports, what we considered at the time to be good progress is actually pretty horrific, was still then. So, I think it's a big issue that has gone unaddressed and that really, really needs attention. And hopefully we're going to also get that data on transports and incorporate that discussion about, because it all started because of a 10-year-old boy and a picture of him in shackles and waist shackle and leg shackles when he was willingly being brought to an inpatient facility. But, people were horrified. The legislature was horrified. We had a big picture of this little boy in shackles. And I think people thought we would address that now.
Yeah.
Or the 6-year-old that was handcuffed. Yeah, we need this.
Todd?
Which quick tie, which relates to the work for judiciary around children and how we treat children. And we don't want them going to adult court. We segregate, we separate and all that, and yet we still put them in chains to transport them.
I'm not really happy with the seclusion part, kids should never be locked up by themselves. But what about the safety of the staff? What if they're out of control? It's like, it seems like that's all I gotta say.
I'll send you the language that exists for other areas, like for instance, transportation. It clearly includes the needs for
Safety of both.
for safety of others and staff of others and the child.
Okay, thank you.
But very focused and limited
No.
on actual risk. Yeah.
I appreciate that.
Yeah. Go ahead,
So
Dan.
this, your bill is trying to just gather information and collect that data so that we know about seclusion and restraint.
And alternatives to them through professional development that is perhaps,
Mhm.
it's your purview, required of
Yes.
those residential programs.
Yeah, I think that one of the sort of elements that happens when you pay attention to something, even if you don't have a law prohibiting it, change starts to happen. And I can use, for example, the reason that one of the reasons that I became involved with this was in my own, oh, there's Barbara, that was in my own school district, was where they were having an excessive use of restraint and seclusion, and came in the news, and it was, it was way out of the norm for the rest of the state, essentially. And fortunately, we had a new superintendent coming in who his clear focus was on students and staff, and his first act was to prohibit the use. And his second act was to provide training and professional development to staff, and they have seen a huge decrease, and they track it every single year. And that's the difference. So paying attention to something, even though we, who knows what we'll end up with a law, but this is, okay, if we are going to start collecting this data in a more systematic way and reporting it, then people will start to pay more attention to it.
Well, as you know, these are some of our most vulnerable children in that they are separated from their families. They, and they're the communities that they know. Many of them are out of state, and they are invisible.
Yeah.
To us in the way that public school children are not necessarily.
Yeah.
It's already in statute that the department shall notify
Yes.
instances of restraint or seclusion of any child or youth in the custody of the commissioner.
Yes, the office has basically said we need to be more specific, and they need we need to direct them to get the information from participating programs.
So we need additional focus. I mean, that's essentially what they're saying. Thank you very much, Professor Blumley.
Yeah.
Thank you.
Thank you.
You are my favorite committee. Beyond mine.
Thank you. Okay, folks. Actually, quite related to this is the next bill presentation, and we have Representative Rachelson, who is here with us on H 192. Welcome, Representative Rachelson. It's nice to see you. We can't hear you yet, but.
Thank you. Thank you for the Zoom in. I'm looking forward to being there in person tomorrow. So, do you want me to?
Yeah, just give us your rationale about why you think this bill is necessary.
Yes. So thank you, Madam Chair, for inviting. I believe Representative Arsenault is also going to be.
Yeah, she's not here yet.
Okay. All right. So.
And we have a time limit, so I just wanted to make sure we didn't wait for Angela to be here since you were here on the screen. So
she and I have coordinated, but thank you for inviting us today to talk about H 192, an act relating to prohibiting solitary confinement of children. For those of you that I don't know, my name is Representative Barbara Rachelson from the Chittenden 14 Burlington District. I'm a social worker and have worked in the field of juvenile justice, mental health prevention, and child and family services for many years. I have visited many juvenile facilities over the years in several states, including the Woodside Treatment Program. I've also, through my work, spoken with many youth who were housed in these programs. So NCSL describes solitary confinement or seclusion as the most extreme form of isolation in a detention setting that can include physical and social isolation in a cell. According to the Academy for Child and Adolescent Psychiatry, solitary confinement of juveniles can lead to depression, anxiety, and even psychosis. During my visit to Woodside, and I managed to get to visit twice, I think, during and once around 2018, I think, I got to see the actual cells that juveniles who were in solitary confinement were in. It wasn't pretty and it wasn't okay. I was pleased that in 2019, a federal judge ordered DCF Woodside to reduce the use of solitary confinement and ease discipline disciplinary procedures. So you might be asking, well, what's so bad about solitary confinement? These kids broke the law and we need to be able to control them and keep the other kids safe. So let me briefly say what the research shows about solitary confinement. The report that I cite most of the research from is the Juvenile Law Center report from 2017. I've sent it to you along with my testimony. Solitary confinement harms kids. Solitary confinement can cause permanent psychological damage and may lead to self-harm, psychosis, and suicide in adults as well as youth. Harsh conditions interfere with normal child development. They traumatize youth. They exacerbate physical and emotional disabilities and cause serious lifelong health problems. Neurological research and sociological studies confirm that common sense tells us about holding kids in solitary isolation for days or weeks at a time has devastating long-term effects. In 2014, Laura Demon had an article in The Atlantic, How Solitary Confinement Hurts the Teenage Brain. And she interviewed Craig Haney, a professor of psychology at UC Santa Cruz, who'd been studying the psychological effects of solitary confinement for about 30 years. He explained that juveniles are vulnerable because they're in crucial stages of development, socially, psychologically, neurologically. One of the major reasons it's harmful is that the brain is undergoing major structural growth. And it's particularly important in the still developing frontal lobe region for cognitive processing, such as planning, strategizing, organizing thoughts and actions. That section of the frontal lobe, the dorsolateral prefrontal cortex, continues to develop into a person's mid-30s. The experience of isolation is especially frightening, traumatizing, and stressful. These traumatic experiences can interfere with them and damage these developmental processes, and the damage may be irreparable. Second reason, solitary is unfairly applied. Research has shown that youth of color, LGBTQ+ youth, gender nonconforming youth, and youth with disabilities are more likely to be placed in solitary confinement, which administrators sometimes justify as necessary for their own protection or because the facility lacks appropriate services or accommodation. So solitary confinement can re-traumatize youth. And some of these kids have a history of sexual abuse and other trauma prior to entering the juvenile justice system. And third, which I think is also really important, is it's unnecessary and counterproductive. There's no evidence that using solitary confinement increases safety or reduces violence in youth facilities. In fact, the practice could increase violence, and research has shown that solitary confinement often makes things worse. The report that I shared with you highlights Ohio and Massachusetts, who have both drastically limited the practice. If parents treated their kids this way, it would be considered child abuse. So earlier this year in House Judiciary, we asked DCF about the use of solitary confinement. DCF shared that they are not huge fans of using solitary confinement, but we're not necessarily in favor of prohibiting it. They have administrative rules right now to address it. This concerns me. And one reason is that as lawmakers, we need to decide if this should be a tool that we allow or not. Leaving it just up to DCF to decide if they want to use it doesn't seem appropriate to me. I've also heard, why do we need to do this bill now? We don't even have a juvenile facility. So I want to tell you why now is precisely the time to do this bill. One, we're in the design phase of building a facility. What better time to prohibit the use of solitary confinement so the design can be built knowing that solitary confinement is not an option. We can look at the states that have successfully done it and design accordingly. We are currently sending youth to Department of Corrections or out of state since we don't have a Woodside. We must be clear if we will allow these entities to impose solitary confinement on our children. While Vermont, like other states, requires children held in an adult facility to be separated from the adult population, which is a very good thing, and I'm not advocating to do anything differently, it ends up usually meaning that the youth in the adult facilities are held in the practical equivalent of solitary confinement. And I've already talked about this practice. Sorry, I'm dog and baby sitting at the moment. In recent years, 7 states have passed laws that limit or prohibit the use of solitary confinement for youth in detention facilities. I know Vermont's administrative law talks about 30-minute limits at a time. Again, I think it's really important to draw a bright line. There's no reason for it. I'm grateful to the House Human Services Committee for taking up this issue. And I'm hoping that you'll have time to talk to experts at the Human Rights for Kids, which I will disclose I am on their board, and am very aware of the work that they have done on this issue in other states. I know that one recommendation that they have is that we amend the bill that we submitted to strike the language that defines the number of hours the bill would allow a youth to be in restrictive housing. And I'm happy to talk about that more. But thank you for your time and consideration. This is a really important issue, and the timing is, I think, of the essence.
Thank you. Thank you, Representative Richardson. And we have been joined by Representative Arsenault now. Angela, do you want to add a few comments? We are kind of tight on time.
No, thank you so much, Angela Arsenault from Williston. For the record, Representative Richardson and I were communicating before in advance of the testimony, and I reviewed, checked out what Barbara was going to say, and I feel that she really captured very well my feelings and what we've been sharing, going back and forth, working on the bill. And the one thing I'll stress, I think, is, well, 2 things, I guess, that we were struck by the same thing in the meeting that Representative Richardson referenced, hearing from DCF. Don't worry, we don't use solitary confinement, but also we don't want a law against it. That just raises concerns for me. And not to say that I don't trust, that they don't favor solitary confinement for juveniles, but anytime someone says, but please don't say we can't do it, it's concerning. So that really struck me. And then as Representative Richardson pointed out, the timing of this, and that was another reason that I think that DCF was very, I won't say very, but was not in favor of a law now, because we don't have a juvenile facility, and there are sight and sound separation requirements for juveniles and adult facilities. But Barbara and I feel very strongly that because we're in the design phase of a new juvenile facility,
Be clear about what our policy and expectations is actually probably more important now than.
that we have a rare opportunity to get ahead of a few things and implement policy decisions into design decisions.
Because that facility or, at the current time, the plan is that the running of any services and supports will be by an outside contractor. And so being clear about expectations in those contracts. Go ahead, Representative Steady.
Same thing as I said before. I don't see it being taken right out because it could be self-harm to the child. We're talking some 17-year-old kids are quite strong, could hurt somebody or hurt themselves. And I'm not saying 17, I'm just saying some kids are adult size or self-harm. I've seen kids batting their head against the walls, and so I can't see it taken right out, but with strong language only to be used in a safety issue type thing.
Yeah,
For both adult and child. But
I understand that. And right now the draft does have those types of situations, I think, with some
Emergency.
Yeah.
Oh, thank you.
I like her words.
Eventually, 21-year-olds might be going to, what do you call it? Juvenile court.
20-year-olds.
Well, it could be 21-year-olds, almost 22. and they're pretty strong.
There's no bill, there's nothing
No.
currently in law that would
No, yeah.
allow 21 or 22-year-olds.
But they're working on that right now, and it might,
I'm not aware of anyone who's working on that.
actually, we were on a committee and
I read it.
I'm just worried about the larger. I'm really worried, I wish we had an age thing here,
Not 21.
you know, because like Brennan was saying, 17-year-olds or 20-year-olds, they can,
Yeah.
they can do some damage.
Yeah, and I think that, no matter how big or small a person is, their brain development is going to be roughly the same within a range. So I understand what you're saying, and violence is always a concern. Both a threat of violence to others or self-harm certainly needs to be need room to address that.
Okay.
But I want to make sure that we understand that brain development, has nothing to do with physical size.
Thank you.
Thank you.
Thank you. Okay, you haven't spoken.
Just
so,
very-
yeah, go
very
ahead.
quickly.
I'm just trying to make sure
Anyone
that we
has
have time to get over to the early childhood day, so.
Perfect. If anyone has any questions of why this is necessary, they should read Loss of Grace, an article by 7 Days from October of 23.
Actually, send a link.
Yeah.
Happy to do so.
Thank you.
Yeah, I think that
That's
article
good.
really beautifully and tragically captures what can happen
Mhm.
when children are subjected to solitary confinement, and that when you don't have rules in place or laws in place prohibiting it or strictly limiting it, and it's left up to the discretion of folks running the facility, then you're leaving a lot to chance.
Yeah. Okay. Thank you very much, both Representative Rachelson and Representative Arsenal. Appreciate that. And we look forward to further discussion about this important issue.
Thank you.
Alrighty.
Thank you very much.
So folks,